Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Let's talk about at-will employment. My experience has been most employees believe that because they are at-will employees, that their employer can terminate them on any ground. Well, that's not true. I want to look at it from the perspective of what it does not mean to be an at-will employee. Number one, if you have an employment agreement with the company that you work for, that's critical, even though you are an at-will employee. However, that does not give the employer the right to break the contract. The company still has an obligation to keep or honor the contract. So in order to determine whether that employer has breached any agreement between you and the company, you must look to the terms of the contract. Of course, every jurisdiction or every state is going to have its own laws and rules, but it still is going to fall under contract law. Two, an employer cannot discriminate. Let me say that again. An employer cannot discriminate. Whether you have a contract or not, or whether you work as an at-will employee or not, an employer cannot discriminate against you. So let's look at those areas that the Equal Employment Opportunity Commission prohibits employers from engaging in. Discrimination based on disability, race, age, retaliation. Retaliation is huge because irrespective of which area of discrimination is occurring, whether it's disability, race, age, sex, for example, my experience is that retaliation almost always accompanies that discriminatory charge. So look out for that. Sex is another area that's prohibited. National origin, religion, and gender. Very interesting. Genetic Information Non-Discrimination Act. This is really important because employers are able to engage in discrimination, and a lot of times the employees don't even realize it because they're basing their hiring or their termination, advancement on the person's genetics. Yes, their genetics. So look out for that. But I want you to see the areas that the EEOC prohibit employers from engaging in. Again, you don't have to have a contract, an employment contract, and you can be an at-will employee. It doesn't matter. If the employer discriminates on any one of these grounds, you as an employee has a right to file a discrimination charge against your employer. If you believe you have been discriminated against by your employee on any one of these grounds we just mentioned, you can file a discrimination charge with EEOC. Simply go to the link and you will be directed how to move forward. Okay? I hope this helps. Remember, be empowered. Until we see you again, Advocate Lucinda, your empowerment lawyer.